name is Joe Whitcomb, and I am coming to you on Wednesday, January 29th, 2020. I, of course, am the founder and owner of Whitcomb Slinsky PC, and today I'm going to bring you a presentation on basically the fundamentals of filing a bid protest. Now, to put this in context, a bid protest, most of you reviewing this will know what it is. A bid protest is something you file at various stages of the procurement process. It could be filed pre-award bid protest in an instance in which you discover a defect in the solicitation itself, or it could be filed post-award when you believe that the procurement process was either carried out incorrectly or resulted in an unfair outcome. Either you might believe yourself that your company should have been the awardee based on the evaluation criteria, or you may learn that the contracting officer did not apply the evaluation criteria in the way that the request for proposals stated that it will. The first type of bid protest is one that you actually file with the competing agency. So that's referred to as an agency level bid protest. The second type is a GAO bid protest, and that's the Government Accountability Office protest. They have their own set of rules, and they are covered under 4 CFR, I think it's 4.2, 4.21, but all of those will be covered today. The requirements for filing a bid protest basically means that you have to have been your company must have been adversely affected by a rule violation in the procurement process. So again, the contracting officer or the contracting staff has to have done something that was out of bounds as it relates to the federal acquisition regulation or a federal statute, and you have to have been negatively impacted. So just finding a rule violation isn't enough. You have to find a rule violation, and then you must demonstrate to either the GAO or the contracting officer or the Court of Federal Claims that violation negatively impacted your company, or the way that's typically termed is that you were prejudiced. Again, the third type of bid protest that I didn't cover is protests that are filed at the Court of Federal Claims, which is a court in Washington, D.C. It's a court of unique jurisdiction. All claims born in contract against the federal government have to be filed in this court. They cannot be filed in any other U.S. district court. So again, you have to have a rule violation, and that rule violation has to have negatively impacted you. Under an agency level protest, you can file an agency level protest with the agency that again, released the request for proposals, the evaluating agency. Typically that is done under the same time requirements that are covered under the GAO CFR, which is again 4 CFR, I think 2.1 or 21 rather. And the regulation there basically states that you have 10 days from when you knew or should have known about the problem with the award. So if you get a notice of award and you look at it, you review it and say, hey, we should have been the awardee, or this awardee shouldn't have been given the contract, you have 10 days from the date of award in order to be able to file your protest. Now, there's an exception to that if you request a debriefing and the debriefing is required. And debriefings are only required under contracts that are competed under FAR Part 15, which is the FAR provision that covers negotiated procurements. If the contract is competed under FAR Part 12 or 13 or 14, a debriefing is not required. So you have 10 days to file your bid protest from the date that you were noticed of the award if you're not the awardee. Now, if it is a pre-award bid protest, or sometimes referred to as a defective solicitation protest, you have up until the date and time that offers are due. So if, for example, there was a procurement that came out on January 1st and proposals were due by January 31st, 20, then you would need to make sure, and it was at 4 p.m. And the procurement announced, the RFP announced that proposals were due 4 p.m. Eastern time. Then if you're going to file a GAO bid protest as it relates to a defective solicitation, that would need to be filed at the GAO prior to that 4 p.m. deadline of submission. If it's a post-award, again, you have 10 days after the award of the contract to make that protest filed. And it applies whether it's at the agency level or the GAO. Now, if you file something at the agency level, the agency has 30 days to respond to your protest and make a decision. And then that starts a new 10-day clock if you want to go to the Government Accountability Office or GAO and escalate your protest to that level. Now, many solicitations or RFPs, requests for proposals, will announce that there is a agency level appeal for agency level protests. Usually that goes to a senior contracting staff, a director of procurement in a particular area, and you can escalate your protest there. Sometimes the value in doing that, just so if you're curious as to why you would want to do that, is it can sometimes be a valuable intelligence gathering mechanism for finding out, hey, why did the agency, especially if the agency didn't give you a thorough debriefing under FAR Part 15, then you can regularly find out, hey, why is it that the government didn't award it, or at least what's the position the government is taking on why it did not award me this or my company this contract. Again, beyond the agency level protest, you have the GAO level protest or the government accountability level protest. Those protests are filed at the GAO. There's a website that the GAO stood up about a year ago, the EPDS website, and that is where those protests can be filed. Now, your job is to get that protest filed no more than 10 days after the notice of award or notice of intent to award. And again, this all has to do with the solicitation itself. Another video will deal with size standard or status protests, which are filed at the Small Business Administration. But for the purpose of either a defective solicitation or a post-award bid protest based on technical criteria, the Government Accountability Office is where those protests are filed. You can also file protests relative to Procurement Integrity Act at the GAO, but those are far rarer protests than the protest for technical reasons. So if the contracting officer, for example, found that your proposal was not technically acceptable, that would be a reason for you to file that protest at the Government Accountability Office. And again, you have 10 days from the date of the announcement. Now, if you wish to affect a stay of the procurement, that 10-day rule still applies unless a debriefing is required and you request a debriefing. Then it is the later of 10 days from the date of announcement of award or 5 days after you have gotten a formal debriefing. There is a separate deviation for the Department of Defense on debriefings on procurements that are in excess of $10 million. Again, that will be the subject of another video on because the Department of Defense in those instances has an enhanced requirement on the debriefings that they submit back to the disappointed offerers. So again, at the GAO level bid protest, you file that protest at the EPDS. You can just Google a GAO EPDS website, and that'll take you, and you have to create a user profile and file your protest there. Have your solicitation number handy. And again, you can do this pro se. The difficulty which means without the benefit of an attorney, the difficulty in doing that is that the government will redact everything you get back. You won't get to receive very many documents that are unredacted without the benefit of an attorney and the benefit of a protective order. So once you filed your protest and the government is charged with getting you an administrative record back within 30 days, the government will regularly engage in motions practice. They will file very often a motion to dismiss based on the merits of your claim or their perceived lack thereof, or they will issue a corrective action and say, hey, we're going to take another look at this. The contracting officer may have screwed up. We'll take a look at it and maybe we'll issue another solicitation. Those motions to dismiss based on corrective action are regularly granted. It is not normally a worthwhile effort to protest a corrective action because GAO will typically grant those motions. If the government does not grant or does not rather motion for dismissal or issue a corrective action, then they have to give you an administrative record within 30 days of the date that you file your protest. And then that is a new starting gun for you to submit a 10-day to submit within 10 days comments on the agency report. A failure to do that will result in and it's very restrictive. You will not likely get additional time other than the 10 days, unless there's extenuating circumstances, sometimes holidays, but you need to request leave for an extension well in advance. And any additional grounds for protest that you might want to raise, you won't be able to raise those outside the 10 days. So inside those 10 days, once you get the agency report, that is the time to review that record and look to see whether there are any additional grounds for bid protest, which can be raised, again, within that 10-day window. So if you learn through, for example, through the review of the administrative record that the contracting officer was engaged in discussions with the awardee and did not engage in discussions with you or your company, that would be the basis for, and you hadn't already raised that issue in your original protest, that would be the good time to raise that as an additional grounds for protest. That will usually start a new clock for the government and for you to do responses. And the GAO engages in what is an interactive process to let you know, okay, we have this many more days to do anything new that you want to do as it relates to those additional claims. The last step or the last, and these are not sequential, by the way. And they're not necessarily mutually exclusive. You could file an agency level protest or not. You could file a GAO bid protest first or not. And you can go, as we sometimes do, you can go straight to the Court of Federal Claims, often referred to as COFC, for filing a complaint, which is an actual civil complaint, Court of Federal Claims under that court's bid protest jurisdiction. Regarding protests that are filed at the Court of Federal Claims, there is not the stringent 10-day deadline that you are or may be acquainted with at the Government Accountability Office, or GAO. The timeliness requirement at the Court of Federal Claims is simply one of reasonableness. You cannot take an unreasonable amount of time in order to file your bid protest, or it will be dismissed based on timeliness. But normally, and the courts have been essentially all over the board on what is a timely filing at the Court of Federal Claims, or some case law that says 30, 60, 90 days is not unreasonable when it comes to a disappointed offer filing a bid protest in a post-award setting. There is a Court of Appeals for the Federal Circuit case referred to as Blue and Gold that says that if you want to file a complaint about a defective solicitation or some level of patent ambiguity in the solicitation itself, you should not wait until after the award to raise to file that complaint. And the way the case Blue and Gold reads is that the court's instructed, hey, you shouldn't lie and wait, find out if the ambiguity serves you, and then if you're not awarded, then pounce and allege that the solicitation was ambiguous. Instead, you should file that complaint when you learn about it, or at least in advance of the responses to the RFP being due. So the value of filing a case at the Court of Federal Claims is, again, you're going to be in front of an Article I judge. These are judges that are appointed by the Senate, appointed by the President, confirmed by the Senate. They are, the federal rules of civil procedure apply in that case, and as it relates to bid protests or special rules. All of those cases are decided on motions. There's never a trial. There's never a jury. There is regularly oral argument that takes place in front of a federal judge, a Court of Federal Claims judge. That, again, there's one courtroom. It's in Washington, D.C., and they have a pretty steady docket of these bid protest cases. The briefing is done in an accelerated fashion. You can also file there. What I didn't mention previously is if you file a GAO bid protest and you file one timely at the GAO, that usually results in what's called a stay, which means the contracting office is not allowed to move forward with the award of the contract if you file the protest in a timely manner. That is not the case at the Court of Federal Claims. And at the GAO, they've got to wait until the GAO has issued a decision, or they have to file a written explanation as to why they've overridden the stay. And the overriding of those stays is something that can be, again, you can file a complaint at the Court of Federal Claims about the agency overriding the GAO stay. But if you go to the Court of Federal Claims, there is no automatic stay in place. Instead, if you want to stop the progress of the procurement or keep the procurement from being awarded and performed, then you're required to file either a TRO or which is a temporary restraining order, or a motion for preliminary injunction, in which if the court, which is again argued on motion and regularly requires oral argument, and if the court comes down your way, then the government will not be allowed to go forward with the procurement until the protest is completely resolved and adjudicated. Those are just the three different examples of places where you can file bid protest: at the agency, at the Government Accountability Office, or at the Court of Federal Claims. If you file again at the Court of Federal Claims, it's essentially what I describe, or the court describes as a trial on the briefs. The government is required to put together an administrative record, submit that administrative record to you and to the court, or to your attorney in the court. And then you are allowed, and again, you are not allowed to be pro se at the Court of Federal Claims. In other words, you have to have an attorney there because, again, there's a protective order in place in most instances, and you have to be represented by counsel. So if you go to the Court of Federal Claims and you file your complaint, then the court will put together a scheduling order, and you'll have to file a motion for judgment on the administrative record, and your attorney will file a response, or the government will file a response, and then you reply, and then the government replies, and then you're all meeting in DC and doing an oral argument normally. Sometimes those oral arguments can be done over the phone, but normally they're done in person. So those are the types of bid protests, the timing on those bid protests, and normally a Court of Federal Claims bid protest from cradle to grave, front to back, will take you anywhere from 90 to 120 days to have a decision on that. They're intentionally very quick because the understanding is that everything in the government procurement universe is either grinding to a halt or at least is unclear, and so the courts like to get those decisions issued pretty quickly. So that's all I have on the 30,000 foot view on bid protest. If you have any questions about bid protest, of course, you know how to reach me. We're at Whitcomb Selinsky PC. We represent a lot of veteran-owned businesses across the country. We've done a lot of cases at the Court of Federal Claims. We're happy to counsel you on whether a bid protest at the Court of Federal Claims or the GAO or at the agency level is advisable. So again, we thank you for your time. I hope you have a fantastic day and look forward to talking to you again on our next video.